Hello, this is Law and Terrorism, the podcast series. I'm your professor, Glenn Torres-Spelliscy. Thanks for joining me. Thanks for joining me for this week's edition of 5 Key Questions. The topic this week relates to the fundamental concepts of criminal law. In last week's lecture, we began addressing concepts of state responsibility. We will now begin addressing concepts of individual responsibility for terrorist acts. So let's get started. In both domestic and international criminal law, crimes are composed of two elements. 1. Conduct, meaning either an act or omission referred to in the context of criminal law by the Latin term actus reus, which literally translates to the defendant's act. And 2. A guilty state of mind, referred to by the Latin mens rea, which literally translates to the defendant's state of mind. It is important to realize that a wrongful act in and of itself is not enough to make a person criminally liable, and neither is a guilty mind. In order to be criminally liable, the person has to not only commit a criminal act, but also has to have the mental responsibility for that act. The most common form of responsibility is intent, meaning generally that the individual intended the natural consequences of their actions. Now, intent is different than motive. A motive is why you did something, whereas intent just means that you understood what the likely result of your action would be. Intent doesn't get into the why, and that is an important distinction to understand. Some international crimes require a special type of intent, called specific intent. That means that you not only did you intend the natural consequences of your action, but your action is also part of pursuing a specific, larger goal. This is probably one of the most important concepts and ideas in the law, and is also, frankly, misunderstood by a lot of people. The idea of jurisdiction relates to when a state or entity has the power to act. In terms of judicial jurisdiction, it refers to the circumstances that must exist in order for a court to exercise its binding authority over the individual. For example, a court in France would have no power to exercise its authority over an American citizen accused of robbing a liquor store in the state of Florida. It's a fairly basic example, but the cases become more complicated in the cases of international terrorism, where the interests at issue often span borders. In short, the principles of jurisdiction are based on the fundamental premise that there should be some type of connection between the crime and the criminal, and the state that seeks to prosecute. There are 4 basic jurisdictional principles that grant a state jurisdiction to criminally prosecute an individual: territorial, nationality, protective, and universal. Territorial jurisdiction is the easiest and the least controversial. It provides that whatever happens on the territory of a state is of that state's primary concern, and that the state and its courts will be assumed to have jurisdiction to prescribe conduct and adjudicate any disputes. Nationality jurisdiction means that a state can exercise its jurisdiction over its nationals anywhere. So if an American citizen breaks an American law while abroad, the U.S. can still prosecute. A subset of this type of jurisdiction is called the passive personality jurisdiction. That means that if the victim of the act is a national, then the state can also claim jurisdiction. This latter type is more controversial, but has generally been accepted if the person is the victim of a terrorist attack. Now, the protective nexus provides that states have an interest in protecting themselves against certain acts, even if performed outside their territory, that threaten the key and vital interests of the state, i.e. attacks on state interests abroad. So, for example, terrorist attacks on U.S. ships committed at foreign ports can still be prosecuted by U.S. courts under this principle. The final jurisdictional principle that we will discuss is called universal jurisdiction. This theory of jurisdiction provides that certain activities are so universally condemned that any state has an interest in exercising jurisdiction to prescribe and punish the acts. It really is reserved for the worst of international crimes like piracy, slavery, genocide, and crimes against humanity. We've all seen the Hollywood movies where an evil foreign diplomat cannot be prosecuted because of diplomatic immunity. But what exactly is immunity, and when does it apply? Even if a state has jurisdiction over a particular individual in crime, especially when dealing with acts of state, including state involvement in terrorism, the court has to determine if the individual or entity is immune from prosecution. Immunities serve as an additional limitation on the right of a state to assert jurisdiction, particularly over foreign government and foreign officials. Now, there are two categories of personal immunity under international law that limit the ability of a state to bring a case against an individual. First, there are functional immunities that arise when a person is acting in an official capacity as a representative of a state. The rationale is that when acting on behalf of the state, it is the state that should ultimately bear responsibility, not the individual. Note that this type of immunity only protects the public life, not the private life of the person, meaning it only functions when the person is operating in his or her official capacity. These immunities arguably do not end when the individual leaves office. Importantly, there is a strong argument that functional immunity will not make a state official immune from prosecution for international crimes. The second category of immunity is referred to as personal immunity, and this is what is typically called diplomatic immunity. It is governed by the Vienna Convention on Diplomatic Relations, which has been ratified by virtually all of the world's states, including the United States. The concept is that certain state officials are immune from prosecution during their time in office. If they were not immune, a state could interfere with the person's official duties by subjecting the person to endless levels of harassment. This type of immunity applies to both the public and private lives of officials, but importantly ends when they leave office. The immunity also belongs to the foreign government, not the individual, and the foreign government can, and often does, waive immunity when it is a significant crime. Some treaties, including the Statute of the International Criminal Court, now explicitly provide that personal immunities does not shield an individual from prosecution for international crimes. One of the key issues confronting states with respect to the exercise of jurisdiction is coordination across multiple states. Indeed, in the counterterrorism field, coordination across states and mutual assistance are key determinants of the success or failure of any particular operation. If one state has control over the individual but another state has jurisdiction with respect to a particular action, how do the two states coordinate to ensure that the jurisdiction and sovereignty of each is respected, while also ensuring that justice is done? In international law, this is done through a concept that most of you are probably familiar with: extradition. The concept of extradition is very old, and basically it allows states to provide aid to another state's jurisdiction by sending or transferring the offender to that state. Now, importantly, extradition is treaty controlled, and it's not a principle of customary law. There is no general obligation to extradite anyone, except arguably in cases involving human rights laws and anti-terrorism laws, where there is a duty incumbent on states to either prosecute individuals or extradite them to a country that will. There are a few general principles that are contained in most extradition treaties, and that will help determine when a state will extradite an accused individual. The two primary principles are the principle of specialty and the principle of double criminality. The principle of specialty provides that a state will only extradite an individual when it receives assurances that the individual will be tried for the crimes that he or she is extradited for. The principle of double criminality provides that extradition is only available if the offense with which the individual is to be charged is an offense under the laws of both the extraditing state and the receiving state. It doesn't have to be an exact match in crime, but it must be similar in principle. The key question here is whether the fugitive could be punished for the act in both states. And finally, states are unlikely to extradite an individual if the alleged crime relates to political activity. Importantly, the political exception does not apply if the individual is charged with international crimes. Some states will also refuse to extradite an individual if the extradition is likely to result in human rights violations. This became an issue in the War on Terror, as the U.S. often sought to send people to foreign jurisdictions with spotty human rights records for interrogation. Well, rendition simply refers to the legal process of extradition. Extraordinary rendition is the removal of a person outside of that legal process. Now, in most cases, in order to extradite a person, there needs to be a formal removal proceeding. In cases of extraordinary rendition, however, The government simply places the individual on a plane and removes them to another jurisdiction without any hearing. As we have seen in the War on Terror, the removal was often to places where there are questionable human rights practices, like Saudi Arabia or Jordan or Egypt, even places like Libya. Indeed, the US arguably used the practice to skirt certain legal requirements that generally prevent the transfer of prisoners to such jurisdictions. Well, that does it for this week's introductory podcast. Let me know if you have any questions, and I will see you next week for a new installment of 5 Key Questions.